Hello everyone, welcome to Agitation Rising. My name is Zachary Getrich. Today we're going to be following up on the viral videos that we released about a week and a half ago showing the violent arrest of Taylor Brown by the Normal Police Department, who attempted to seize her phone without a warrant and then arrested her only to release her later that day with no charges. So, was Taylor Brown's arrest legal? Did the Normal Police Department have a right to seize Taylor Brown's phone without a warrant and arrest her? Now, Brown was at the police station to be interviewed about a fire that occurred at her residence on February 9, 2023. After waiting 40 minutes, Brown decided to leave and refused to consent to an interview at that time. She asked to be taken somewhere for her to sleep. As she waited in the lobby, Officer Serena Cunningham was informed by Detective Tyler Van Weinsberg to seize Brown's phone, even though they had no warrant to do so. Brown refused to hand over her phone, resulting in a violent confrontation between her and the police, which landed her in jail. However, she was released hours later with no charges, and her phone was returned to her. No search warrant was ever granted by a judge for the phone. Brown has since filed a federal lawsuit alleging false arrest and excessive force. The key question is, did the Normal Police Department have a right to seize Taylor's phone without a warrant? There are reasons why police are able to seize property without a warrant. For instance, if while being arrested, a phone falls out of a person's pocket and is picked up by police officers, that could be considered a seizure of the phone. However, Taylor Brown was not under arrest at the time and was free to leave the police station. The police could also seize something if they have a reasonable suspicion that evidence may be destroyed. If the police believed there was evidence on Brown's phone of a crime, and there was a good chance such evidence might be destroyed, then they could seize it prior to getting an arrest. In an interview with local insurrection radio Cities 92.9, Normal Police Department Chief Petrilli said that police can seize property without an arrest or warrant. All that is required before seizing property is a reasonable suspicion that a crime has been committed. Therefore, property is often seized to protect potential evidence. This is especially true of electronics. After the property is seized, police then can go and get a warrant. After getting a warrant, they can search the property, which in many cases is an electronic device. Petrilli used an example of a crime scene. Police can seize an entire property and not allow even the owner or tenant back inside until they have completed their investigation. In a case like this, many electronic devices can be seized along with the property itself. After the property is seized, then police can go get a warrant before searching the property and or items on the property, such as an electronic device. The author of the Cities 92.9 article, Kevin Woodard, told Agitation Rising, quote, "My main thing is we have to educate people so that they don't get hurt or killed. People need to realize that by continuing to resist, and especially by fleeing, that they are putting themselves in harm's way. At some point, it becomes in your best self-interest to just do what they say, then you can get an attorney later." In a WGLT article, reporter Charlie Schlenker interviewed two Illinois State University criminal justice scientists on their thoughts regarding the legality of the seizure and subsequent arrest, Michael Gizzi and Bill Lally. Gizzi called the incident troubling and said, quote, "It was as if the officer was almost goading her. She was escalating conflict instead of de-escalating a situation, continually saying, 'We're taking the phone, we're taking the phone, we're seizing the phone.'" On the other hand, Lally, also a police officer, acknowledged the repetition of the same set of words could be viewed as provocative. But he said the reason officers do that kind of thing likely came from a desire to stay on one line of dialogue. Lally said argument usually doesn't produce a resolution, so officers do not stray from the intent. In this case, they say they needed that phone. Lally acknowledged if officers had clarified what they were after or tried in a different way to talk Brown down as things escalated, they might have reduced tension. But that doesn't mean they did anything wrong at the time, according to him. But the officers were not only requesting the phone be handed over, they were requesting that Brown do an interview with Detective Van Weinsberg without an attorney regarding the fire that occurred at Brown's apartment. Prior to the violent seizure, Officer Cunningham asked in some form or another 10 times whether Brown would do an interview with Detective Van Weinsberg, though Cunningham made it clear the phone would be seized regardless.
That's up to you.
Well, if I do the interview,
you can go do the interview, but your phone's going to currently be seized.
I'm asking you a reason.
So if you would like to talk to the detective, you can.
Why is my phone being seized?
If you would like to talk to the detective that is seizing it, you can. Do you wish to talk to him?
Yeah, but
do you want to get an interview?
No, I wanted to ask him myself like that.
So are you going to talk to the detective? So,
This wasn't
so
said.
the
This
question, so
can't
the
be-
question is, are
As a
you
matter
going
of
to talk to the
fact-
detective?
As a matter of fact, are you recording?
Are you going to talk to the detective and provide an interview? Yes or no?
Is that with or without the phone?
Without the phone. The phone's being seized. Are you talking to the
Like,
detective
how
or no?
long is the phone being
I don't know.
That's
That's not my question.
I need an answer to that before I get.
So the question is, are you going to provide an interview?
After Brown was in cuffs, Detective Van Weinsberg asked Brown another 7 times whether she would do an interview with him without an attorney. Both Detective Van Weinsberg and Officer Cunningham made clear Brown would still be charged with aggravated battery of a police officer and resisting a police officer even if she did the interview.
And look at what you're doing.
Are you willing to provide a statement or no?
What does that mean?
Are you going to talk to me if we go back there or not?
You are forcing me to.
I'm asking you if you're going to
But
provide
you're
a statement.
forcing me to.
I can't force you to talk.
You're taking my items.
I'm seizing this for now, yes.
What does that
Do
mean?
you want to provide a statement?
My detective, I need to talk to her. I need an
Fine.
attorney present.
Okay.
I need a lawyer.
You can take her to jail.
All right.
Take me to
Where's her
jail?
property?
Whatever charges you guys have.
You have resisting and aggravated battery of a police officer.
Oh my God!
Chief Petrilli told Woodard that officers go through high levels of training, and that when they are in situations like this, they refer to their training. What seems clear is that officers were attempting to coerce Brown into an interview without an attorney. Now, if this went in front of a judge, would a judge rule they attempted to coerce her? Probably not. As Chief Petrilli said, his officers are well trained in exactly what to say when leveraging state power against an individual to achieve their ends without running afoul of judicial review. However, and this is one of the things about this case that still gets to me, Brown was released from jail without any bond or any charges. No warrant was ever obtained for her phone, and the police returned it to her. State's attorneys have enormous prosecutorial discretion when it comes to filing charges. Based on the video footage and the incident reports, Brown physically made contact with at least 2 officers. That's 2 Class C felony counts. The state's attorney could have easily charged Brown with those offenses, and Brown would likely have had little recourse until her first pretrial hearing, which could be up to a month after the incident. The state's attorney could also have dropped the charges at a later date. The point is to leverage state power against a person in an attempt to coerce them into cooperating with an investigation. And of course, the state's attorney could still indict Brown on those charges, as the statute of limitations on a Class C felony is 3 years. Yet, the state's attorney has chosen not to do this. If charges were not filed, and a warrant was not granted, then the whole incident was unlawful. At least it should be considered legally unlawful. And Brown was defending herself from police abuse. As ISU professor Jizzy stated, quote, "To me, the true lesson is, and it's an unfortunate one, but I would never, under any circumstances, go to a police department for any interview at all without an attorney present, because you have no idea what the reason is and what they are thinking as to why they want to question you." Jizzy's statement is excellent advice. You have a constitutional right to an attorney. But if you don't have the kind of expendable income to have a lawyer on retainer or hire one last minute, in many ways this right can appear meaningless. One cannot call the public defender's office and ask them to be present for a police interview. In fact, public defender's offices usually won't even talk to you until a judge has officially signed them to you long after you've been arrested. This clearly wasn't the case regarding Taylor Brown. Brown says in a TikTok video about the incident that her mother is a Chicago police detective and she comes from means.
But the main thing I do want to say is, yes, I am suing. Of course, can't go out like that. But another thing I want to say is, if know your rights, learn them, please, because I'm pretty sure if I was somebody who didn't have the resources that I had or didn't have the support system that I had, I wouldn't be in a position to sue. And this would have been another story that just went unnoticed and unheard.
But there's a very real class-based burden to upholding your constitutional rights if you are working class. To be clear, Taylor Brown has not been charged with any crime as of the publication of this article. Should she be charged, she is innocent until proven guilty. Next up, we're going to continue to cover this case as one of Taylor Brown's former roommates makes a bombshell allegations that perhaps Taylor Brown was the one that started the fire at her house. Keep agitating, keep rising, and we'll see you on the other side.